Hey, hello everyone. Welcome to our webinar today, Navigating the Federal Contracting Arena, Insights and Updates for the Small Business. I'm Kevin Plexico. I'm one of the volunteer leaders here with the JMU Federal Dukes chapter of the JMU Alumni Association, and very happy to have you joining us today. Just a couple brief technology reminders. First of all, your sound and video should be coming through your computer. Just recommend using your audio that's just directly through your computer. So if you want to make the screen bigger, would suggest you put it in the full screen mode and fit to your window. We are going to be taking questions throughout the program today with our conversation with Ken Dodds. But if you have questions along the way, we'll make sure we take those on throughout the day. Just a reminder, those questions are going to be visible to all. So just ask everybody to be positive and professional in their questions, and just be mindful that other people will be able to see your questions. So as I mentioned, I'll just take a brief moment to introduce myself. I'm Kevin Plexico. I am Senior Vice President for Information Solutions at a company called Deltek. Deltek is a software and information company that provides project-based businesses with software and information to help them in their business. And obviously a large part of our business is selling to the government contracting community. I am a volunteer leader on the JMU Federal Dukes Alumni Association chapter. So really pleased to have you with us today. Just a little bit of level set on the JMU Federal Dukes Alumni chapter. You know, our focus is really on bridging that community of people from JMU alumni, faculty, and students with the sort of lifeblood of the economic development and growth that we see from the government contracting and employment community that's primarily based here in the DC area in Northern Virginia, but obviously a nationwide and even worldwide sort of network of organizations. And we're really, you know, focused on trying to bring together those communities for the sake of accelerating the mission for JMU. Some of our strategic priorities, and this is where I get involved in one of my roles as program committee chair, is increasing awareness for what we're doing, increasing the awareness of the federal government mission and the opportunities that are available for JMU alumni and students in their careers. Preparing future employees, so providing information and insights on some of the opportunities and issues that face this community, and then building pathways and sort of an ecosystem for the JMU community and the government contracting and government employment community as well. So very pleased to have you today for this program. I appreciate you joining us. Just wanted to share a little bit about our leadership team of volunteers that we have for the JMU Federal Dukes. Many of us, well, obviously all of us came from JMU, but many of us are in leadership roles sort of across the industry, some of us with our own companies, some of us leaders in other companies, but obviously a very dedicated group that volunteers their time to accelerate this mission that we have here. I'm going to go ahead and jump into our program today. You know, as I mentioned, I'm Kevin Plexico. I'm responsible for our information solutions at Deltek. Many of you might be familiar with the GovWin solution. I manage the GovWin research team and product at Deltek. I'm going to be moderating the conversation with our speaker, Ken Dodds, today. Ken, I'll maybe let you introduce yourself a little bit more, but Ken is Vice President for Acquisition Policy at the Coalition of Government Procurement. He joined them just a little over a month ago. Prior to that, he was with a bank, a Live Oak Bank, and prior to that, he was basically the head of policy for the Small Business Administration. So very appropriate background relative to the topic we have today. Maybe Ken, can you maybe talk about a little bit about your background? I know you're obviously a JMU alumni as well, so appreciate you joining us today, but maybe thought a little bit about your background and sort of what your new role entails at the Coalition for Government Procurement.
Yeah, thank you, Kevin. We did this last year. I think it was a good session. Class of 91 from JMU, go Dukes. I'm now the VP of Acquisition Policy at the Coalition for Government Procurement, and we represent government contractors kind of like a trade group advocating for common sense procurement policies from large businesses to small. Before I joined the Coalition, I worked at a bank for almost 5 years doing a lot of mergers and acquisitions in the government contracting community. And then at SBA for 20 some years, I started out as an attorney there doing GovCon and then became the senior executive for procurement policy. So worked on all the rules over that span that came out from SBA, as well as did a lot of the goaling, size standards, and things like that.
Great, terrific. And Are you settled in at your new role yet? I mean, obviously you had the holidays, you got a lot going on, but you feel like you got your
Yeah,
feet under you there?
the government, they like to put out rules like right before Christmas, and so we have to comment on all those rules. So we were very, very busy, but we have a good team, and we turn it around. We also rely a lot on our coalition members, so they give a lot of input into the comments that we give to the government on behalf of them. So we kind of speak for them. So it's not a one company saying this; it's the community is saying this.
Yeah, great. Well, really appreciate you lending your expertise to our community here, and we were doing a little bit of prep for the conversation we're going to have, and there's obviously a lot going on in the small business industry within the government contracting space. Some things helping, some things maybe putting up some challenges. I thought we would maybe start with where things stand relative to sort of the administration, the Biden administration coming into office, and one of their diversity, equity, and inclusion initiatives was to lay a challenge down for the executive branch to increase their utilization of small disadvantaged businesses to 15% over the course of, I think it was 4 or 5 years. Where do you see that sitting today? How do you think things are going from the point of view of that initiative?
Yeah, it's interesting. The statutory SDB goal is 5%. And when we gave agencies their goals and their scorecard, as a government, we usually were doing around 9 or 10%. So the way that would work is that agencies kind of got extra credit for going on over and above that. So they were, the goal was 5, they were doing 10, and so that would help them. And so as we met the small business goals and they met the SDB goal, a lot of the agencies would get, higher grades, A's and things like that, and the government as well. As you raise it, and as they have, like I guess in 22 the goal was 11 and the government did 11.3. This year I think it's 13, and then next year going, supposed to go to 15. So that's going to put, if agencies want to meet that goal and you know get a good grade, they're going to have to actually do a lot more than they had been doing in that area. One of the ways that you might be able to do that is through sole source contracting, especially with some of these larger companies that count as SDBs like ANCs, tribes, and NHOs. So we won't really know what the data shows until years from now, but that can be an easy way for agencies to go after that credit. Um, and then I think in this latest NDAA, they actually raised the SDV goal, the service disabled veteran owned goal, to 5%. It had been 3%. The government had been meeting that as well, 4.5% back in 22. So now by raising that to 5, now you actually have to also do more to help meet that goal if you want to actually get an A as an agency. So there's a lot of pressure on agencies to meet these various categories. And if we've only met the women owned goal once, and as a government, we've never met the hub zone goal. So a lot of different things to juggle as an agency.
And what do you see? I mean, I think that's a really good point, because one of the things that I've heard from companies uh, is sort of the challenge of, does this, increase in SDB come out of the the skin of other small business types, or does it come out of large businesses? And I'm just curious, like, as we talked about increasing the SDB goals, SDVO also going up, like, do you sort of and a lot of these small business programs compete with each other. Just curious how you see that sort of playing out. Do you think it's going to come out of large and mid-sized companies? Do you think they're going to be able to sort of spread the wealth there, or do you think one's going to eat into another one?
It's hard to say, but as a government, we've done really well. I think we've met the small business goal for over 10 years now, I think. And so I think um, you always get small business credit, though. If you award to a women-owned business or an SDB, you can get double, triple credit. If whatever that company has, you get all that credit towards each of these goals. So I would suspect that if you really are going to make an effort to meet a higher SDVO goal and a higher SDB goal, you will have to take some of that maybe out of the small, what would have been small. Now, there are protections, especially for going to 8A, because the only way to really get SDB credit is through an 8A contract, sole source or competition. There are self-certified SDBs out there maybe, but you can't do a set aside for them, so it's hard to target them. So the only real way is through the 8A. Now, I think historically 8A made up maybe half of the SDB numbers. I don't know where they are now. When I was at SBA, it was about half what was through that. So the only way to target it is through that, but there are protections like adverse impact that we might talk about later, where if a small business is performing something, you're not allowed to take it to the 8A program if everything works the way it's supposed to work, if it would really impact that small business. So there are protections there. They're not always followed. They're not always known. They're not always known how to do it, but there are some limitations.
Yeah. Yeah. I just find it interesting, sort of like from a business perspective, the gaming strategy that goes into sort of some of this in terms of how companies compete. I guess in that vein, one of the things that I think even prior administration, OMB and GSA have been pushing forward is this concept of category management, and category management is sort of aspiring to drive the government to better buying practices and better contracting practices. But it's also sort of been observed that it could be impacting, and I think probably is impacting small business contracting. And there's been some things that sort of give credit for small business work. And you maybe talk about what your view is on category management and how it's impacting the small business community?
Yeah, I mean, when I first got in government, it wasn't called category management, it was called strategic sourcing. The concept's always been there. Let's, instead of having 20 different contracts, let's have one. Let's try to get the best contracting and have all the agencies use it. Um, in my experience, those would be set up and some agencies would use them and some would choose not to. It wasn't really until they started goaling agencies on their category management spending, and that got the attention of CFOs and other managers who may not have been that involved in the whole process. When the White House or OMB is grading you on how you're doing on tier 1 and tier 2 category management, that to me is what drove agencies to really start using these vehicles. When I first talked to people, for example, with Oasis, which is a well-known best-in-class contract, that was supposed to be, for the top 15% of the most highly technical work out there. They had a target in mind. They weren't trying to take over the whole market. That was, decades ago, I guess, when they first started. But then as agencies started getting these goals, some agencies would say, well, the only way for us to meet our category management goals is if we only buy from Oasis. Like, I think it was an agency, it might have been Treasury, I'm not sure which one it was, but that was a policy that came down. So if you want to buy these types of services, you had to use Oasis. So that was obviously, if you weren't on that contract, people, panicked, obviously, because stuff they had been doing as a contract was now going to go to that Oasis. So that's why we've had a lot of litigation around these vehicles as well. People are desperate to get on these things because they don't want to be shut out. Because these things can last 10 years. I think the administration tried to help alleviate a little of that with the M2203 memo. And one of the things they did in there is they gave agencies category management credit for using socioeconomic set-asides like 8A or Hub Zone or SDVO or women owned. So they were able, if people are aware of this, it's not, may not be well known, but it's a way for agencies to still get credit and to use more localized contracting and not use these massive big contracts.
One of the things that I'll put on my market research hat in my role at Deltek that we've observed is as we've seen this, sort of adoption of category management, I think we've also seen, and we can talk about this in just a minute, some increasing compliance requirements that have showed up. It seems like the number of unique prime positions in the market, even though agencies are spending more than ever, the number of prime contractors we see participating as primes has dropped, by something like 20 or 30% over the course of the past 5 or 7 years. And the question is, to what extent is category management driving this? To what extent are some of these compliance requirements driving this? I know we've started to see the SBA and OMB sort of, it seems like they're starting to sort of recognize this pattern of like, hey, we're meeting our small business goals in terms of dollars, but what are we doing to the participation levels? Was that something that when you were at SBA that was a topic? And, how have you seen that sort of topic manifest in the last few years since you've been out of the SBA?
Yeah, it was definitely a topic and it was certainly brought up. Obviously, when you're in the executive branch, if OMB is doing something, you have to kind of do what OMB wants you to do as one of the agencies in that. But we certainly advocated for this. And like I said, I think the goaling has driven agencies, category management goaling has driven agencies to start using these vehicles more to get that credit. And then, oh, by the way, if you use the small vehicle, you also get small credit. So it's a win-win for them. But again, if you're not on that vehicle, you really have no way to play in the game. And so I think, they're trying to, I think they recognize that. And I think Congress did too. I think they did some legislation around the scorecard where you're reporting on how many participants and trying to get agencies to do that too. But it's difficult as an agency when you're juggling this goal over here and all these other socioeconomic goals. It can be very challenging.
Yeah, I mean, you're balancing, hey, we got to spend this much with these different types of companies. We want to use these contract vehicles because they're the preferred contract vehicles, and we got to buy this way. And by the way, we need these companies to comply with all these requirements. It's like it just feels like you're sort of reducing the number of companies that are sort of addressable, and it makes it, certainly a challenge for small businesses that are trying to get these kind of compliance requirements and be competitive when they're basically asked to make a pretty significant investment to meet some of these compliance requirements in order to qualify for these companies. I'm just curious how that plays into it. I mean, I think what we've observed is the administration is starting to do things around education and training. To your point, GSA started their dashboard. I think they call it their supplier dashboard, where they're starting to measure new entrants. There's another term, I think, recent entrants, and then sort of established players to start tracking that, at least start tracking it. But just sort of curious how you think about things like some of the compliance requirements, and how that affects the cost of doing business and how that might, shape over time.
Yeah, I mean, government contracting is not for the faint of heart. It's a whole different regime. It's a whole different mindset. You get your solicitation with 200 FAR clauses in them that you're supposed to be complying with. We're getting the CMMC, the cybersecurity stuff just came out, and that's good. There will be some costs associated with that if you need to get that level. At the lower level, there's self-assessment, but at higher levels, there might be a third party you have to pay to do it, and it could be costly. So, but then again, it's government data. I mean, it's you have to have cybersecurity, so it's really hard to not do it. It's coming and it's going to happen, and it's probably a necessary thing. We just have to figure out a way to manage it. I think part of the drive to try to get new entrants is some of that legislation on goaling and things like that. I think there's been a big growth in other transaction authority, because that's a way, especially for like DoD and other agencies, to get what they really want is that high tech stuff that can help with national defense, for example. But those companies don't want to deal with the FAR clauses and the protests and the 2-year process it takes to award a contract. So I think you're going to see, and you have seen, a big growth in these OTAs consortium. It came into play with the medical, COVID stuff. I think agents, even DHS, I think, is starting to look at it. So you're going to see a lot more of that, I think, because it's a fast way for the government to buy what they think is the best solution or best technology without a bunch of protests and 2-year delays in awarding it.
I've always found it interesting that you see these sort of new procurement mechanisms show up. I remember a few years ago, I would call this a new procurement mechanism, but there was sort of like a sort of fear, uncertainty, and doubt that all of a sudden agencies were using low price, technically acceptable a lot more than they were before. And usually, the next year in the NDAA, you could almost predict that Congress was going to ask for more visibility on what was going on with that particular topic. And we've started to see Congress ask for more insight and transparency around the OTA trend as well. So it's sort of interesting how it's like, hey, we found something that's really helpful. Great. Now we want scrutiny on it.
Right. What are you actually doing over there with all those billions?
Yeah. there was a question, and maybe I'll ask this because it's sort of related to what we were talking about, but you sort of alluded to this that when the SBA was sort of giving out goals to different agencies, the goals were different by the agency depending on where they were. I mean, I always describe it as like if you're buying, in the Department of Defense, it's not easy to use a small business for an aircraft carrier or a jet fighter or something like that. But if you look at organizations like Housing and Urban Development or Department of Education, they're primarily more administrative systems, program management type roles. So they tend to have much higher goals. But I'm just curious, like, you'll see some agencies like the VA obviously uses a lot more with service disabled veteran-owned businesses than some of the other agencies because of their, their constituency, if you will. How did you all go about at the SBA setting goals, and how did you sort of respect the bias that an agency might have, like the VA, for our nation's veterans and their sort of preference?
Yeah, I think, well, a lot goes into it. But really it's a lot of it was based on historical, for the small business. Now, when I was at SBA, we would give everyone the regular, 5% SDB and 3% hub zone and 5% women and 3% veteran. Those were kind of standard statutory goals. And so everybody got the same one. We would negotiate goals kind of based on last few years of trend. So for example, NASA, they're not going to do 90% small business one year and 10% the next year. They're always going to be around 9, 10, 11% small business based on what they buy. It can go up a little bit, but for the most part, it's been pretty consistent. I mean, DoD, of course, is like half the spend. So they really drive how the government does when it comes to small business contracting. They were always around 21, 22%, 20, something like that. And then places like SBA where I worked, they were doing 80, 90% small business, so we would kind of try to negotiate that based on, past spend. I think the interesting thing that happened after I left is with the higher SDB goals, SBA added that. We also did subcontracting goals too. We had to negotiate those, but they added SDB goals to a negotiation. So some agencies like State Department might have 20%, or some might have 30% SDB goal where others have lower. Again, probably based on past spend. You could also look to your point, what they buy to see if there's a lot of SDBs in that field, then they maybe should have a higher goal. Whereas if there aren't a lot of SDBs in what you're buying, then maybe you could argue we should have a lower goal because there's nothing available for us. So that's kind of how it is. A lot of it is based on historical, but it can be to some extent, if you put the time in, you could look at NAICS codes and kind of figure out where there's possibilities.
And did you find a lot of it was just like, hey, this is sort of where you've been. We just want you to get a little bit better every year, sort of just incremental improvement in how we can optimize this?
Yeah. And again, we're all in this together. We all want to meet the 23% goal. So if you start giving this agency a lower goal and that agency a lower goal, we're not going to meet it. We're all in this together. And I think, we got pushback, but I think most agencies in the end were pretty comfortable. I think the VA was always upset because they have to go vet first. And so their SDVO or veteran numbers are through the roof, but it's harder for them to go 8A, for example, or hub zone or women owned, because if there's market research that shows veterans can do it, they're supposed to go veteran first. And so that was always their challenge. Now, again, if you award to an 8A SDVO, you get both credit. So that's kind of what they had to do if they wanted to try to get those other categories up as well, is try to figure out ways to include companies that had dual certifications or triple or quadruple.
Yeah. Let me pivot to the topic of joint ventures. I think it's unique, as so many things are unique in the government market. Joint ventures is another example where we see a lot of joint venture activity between companies in pursuit of work. Maybe you could talk just a little orientation for those who might be less familiar with joint ventures and their unique sort of place in the government space with respect to the mentor protege program, just as a level set.
Yeah, back in when I first started SBA back in the 90s, they actually created this this process where 8A companies that were in the 8A program could team up with a large business that was an approved mentor, and they could joint venture together and perform 8A contracts or small contracts together. And that's kind of the origin of it. Over time, other groups like Women Own and Hub Zones and Smalls saw it. And so eventually there was legislation, I think in 2010 and then again in 2013 to kind of kick it off. And I think it kicked off in 2016 or 2017. And it basically allows a small business who may be lacking in past performance or experience to get an approved SBA mentor that, SBA looks at the agreement and makes sure that the mentor is going to help the protege. And then they're allowed to submit offers as whatever the protege is. So if the protege is an 8A hub zone small business, they can joint venture together and offer on small business 8A or hub zone work. And under the way it's set up is the protege has to do at least 40% of the work, and the large business mentor can do up to 60. So if you're splitting up the contract, that's kind of the way that's the benefit for the mentor, and then the protege obviously gets at least 40% of the work share. And that's been it was a popular thing back when it first started, and then as we've pivoted to these large category management contracts with these scoring systems where you have to have a certain number of points, a lot of times the only way for a small business, or at least this is the argument, the only way for a small business to be able to meet those point totals is with a mentor, with a large business giving you some of those certifications or other large contract experience or large past performances. And that, of course, has resulted in all this litigation that delays these award of these contracts for years. Is a lot of it is fighting about how we evaluate these joint ventures.
Yeah, and it's interesting because when you think about joint ventures, I think for some agencies, and we've seen this sort of play out in the way some solicitations have been structured, where the way they treat past performance is, we'll want you what work you did to be based where you were doing that work as a joint venture or this business together. And the sort of pushback on that has been like, well, that's why the joint venture was formed to begin with, was to draw on the past performance. So how have maybe just talk a little bit about how that's been navigated, because I feel like there's been some agencies that have sort of pushed back on that notion of, hey, we don't want joint ventures. We don't necessarily want two companies showing up together that haven't partnered together before to do important work for us. That was the one argument. And I've also seen arguments from other small businesses where they feel like, I can't compete unless I form a joint venture now, because it's gotten to be so competitive with the past performance. So maybe just your view on how that played out. I know there's been some GAO and court rulings related to this, but maybe you could just talk about what you've seen in terms of evolve in that regard.
Yeah, I think if I were a procuring agency, I probably wouldn't really love joint ventures either, because the way, they're typically under the rules, they're unpopulated. So they're really just a shell LLC or company. And then the actual work is kind of basically subcontracted to the partners of that. So they're the ones really, really doing the work. But what we have are statutory provisions that say, you can do them in a protege, and you can't require the protege to meet the same past performance and experience requirements as other offerors. And so that's led to a lot of this. A lot of the recent past few years of litigation has been around how agencies are evaluating that, especially for these large best in class contracts. So it seemed like, there were cases where agencies would say, okay, I can't make the protege meet the same past performance, but I'm going to require one from them, at least one from the protege, and then maybe two from the mentor, or some kind of system where you kind of balanced it, where you got a little something from experience or past performance from the protege, but not the whole thing, and then limited the mentor to some extent in terms of competing. And I think there were some, at least GAO cases, where it seemed like that they didn't sustain the protest, so they thought that was okay or permissible under SBA's regs. And the most recent Polaris decision that started that whole thing over again at COFC, called SH Synergy, they challenged the way they were evaluating price, and that was a big deal. So they had to go back and start, over again and have a contract price evaluation. But the second part of that was interesting, where the judge basically said, no, you can't even require, let's say the requirement was three $10 million contracts. You have to have that experience or past performance. The judge said, well, no, you can't even require the protege to have one $10 million experience. It has to be even less than what other regular small businesses are offering. And they had some suggestions around, half the size or other ways to give extra credit and things like that in the decision. So that changes things a lot for agencies that are doing this, because while COFC decisions aren't necessarily binding on other COFC judges, they do often follow them. And if you're a procuring agency, if you wanted to do the old, like an old system where you had one example from the protege and two from the mentor and things like that, well, that's great. But if someone doesn't like it, they can go to COFC and probably get that overturned. So I think you have to do a lot more work in terms of setting up how you're going to evaluate joint venture, mentor protege, past performance and experience. And it actually, in my mind, makes the mentor's experience even more important, because now you're even lowering what the protege has to show. So it does seem to me that we'll see, I guess, what the data shows maybe in a few years, but it seems to me that there's going to be a lot of mentor protege businesses on these best in class contracts.
And is that, would you say that, in your opinion, is likely going to put pressure on small businesses to want to gravitate to that in order to be competitive? Like they're almost going to need to have
Yeah, I
or be
think
a part of that kind of thing?
I think it does a lot of things. I mean, it does, if you want to be in the game, you certainly, it should be part of your strategy. There's no question. As a small business, it should be that you should be trying to find a business that you could be, that could be your mentor, that you work well with, and that could help support you. And then as you graduate and become you were small and now you're a dollar over the size standard, now you're large, it has to be part of your strategy in terms of being able to go after work you used to do. Maybe you can do it as a mentor protege joint venture. So as far as the current landscape, this has to be in your business strategy from a small or lower, I think a large as well.
Yeah.
Now it will, there are some proposals out there around, maybe we should have a competition where smalls compete with smalls and the mentor proteges compete with mentor proteges to get on the contract. Maybe we should limit mentor proteges, or maybe I think SBA could do some rulemaking to kind of address this issue with how we evaluate past performance, give a little more clarity or examples. Maybe they could even come out and say, yeah, it's okay to say the protege has to have one and the mentor has to have two examples or something like that. They could, I think, through rulemaking, kind of get us out of this situation where every contract is going to be protested and there's so much litigation around it. So I think that might come out this year, where they might propose something around maybe helping in that area.
Yeah. And even if they did, based on experience with SBA rulemaking and how long it takes to get through the process, are you thinking, what's that, 2 years probably before that, kind of like when it gets proposed and when it gets put
Yeah,
in
yeah.
place?
Realistically, it's at least a year. Sometimes it takes longer. Plus, anything you propose now, obviously there's going to be election, and that could change the directions of a lot of things.
Yeah.
So a
Yeah.
lot of, depending on how things go, some rulemaking won't go forward. So, but you know, when I was at SBA, there's just constantly rules going on, because you're constantly adjusting to how things are. You're constantly
Yeah.
adjusting to legislation. You're constantly adjusting to new COFC decisions or GAO decisions or OHA decisions. So it's just a process that just continues.
Yeah. All right. Well, let's maybe talk a bit, because you mentioned courts, about the 8A program, which is found itself in some court discussions and rulings recently. Maybe you'll just start with a level set. The small disadvantaged business contracting goal. There, correct me if I'm wrong, but there aren't small disadvantaged business set-asides and small disadvantaged business sole sources. There's the 8A program and 8A set-asides and 8A sole sources, but essentially, a key mechanism to get to those small disadvantaged business goals is through the 8A program, right?
Right. Yeah. So the 8A program goes back to, I think, the 60s. It's a term program of 9 years. It's for socially and economically disadvantaged individuals as well as entity-owned firms as well. The great thing about the 8A program is that it has rules that require sole source contracting below certain amounts. So a lot of the other programs have the possibility of sole source, but it's only if you can't compete it. So that the great thing about 8A is that sole source capability, and that's why people are gravitate to it. Um, when there was a case called Adirondack back in the 90s that kind of challenged affirmative action and contracting, and SBA redid their rules around how you got into the 8A program as a result of that, and SDB contracting as well. Back then, when it was allowed, there was like a price evaluation preference. There weren't really a lot of set-asides at that time. But one of the things they did was they said, okay, so to get in the program, to show you're socially disadvantaged, you have to show you've been disadvantaged in employment, education or business history if you want to get in the program. However, there are certain racial groups that don't have to do that. There's a presumption that they're disadvantaged, and there's really no way to rebut that. So if you claim to be Hispanic or Black American or Asian, certain Asian groups, they were basically presumed, and that was in the rules in '98, and that's kind of how it operated up until just last year with this case called this ultimate decision, which challenged that that presumption of getting in the program. Uh, couple interesting things about the case. I mentioned earlier about the adverse impact, and so the plaintiff in this case was a small business, and the procuring agency, I think, was USDA, and they basically tried to take a contract that company was performing and put it in the 8A program, and there's that adverse impact analysis that's supposed to go on, where if it would adversely impact the small business, then you can't put it in the 8A program. And in this case, it actually worked. They went to one district office, and the district office said, no, we can't accept this into the program because it would impact that small business. Somehow the agency went to a different district office and got a different answer. So the requirement went into the 8A program, and this plaintiff went to this court in, I think, Tennessee, and the court said it was the social disadvantage narrative basically was over overturned that or overruled it or said it was discriminatory, violated equal protections. And so in response, SBA, obviously they started to require any applicant to have to fill out a narrative basically describing how you've been socially disadvantaged. Whereas some other people got in the program by doing that. Now everybody had to do that. And then for every contract, as this was at the end of the fiscal year, they employed a bunch of district council and other folks to look at these narratives. And you had to have your narrative approved before you could get an 8A contract. And then, of course, they went after all the other firms in the program that weren't getting contracts. That was the third thing that they had to get to. Now the plaintiff, they won, so they got the social disadvantage narrative requirement overturned basically, but then they kind of went back and asked for additional remedies. They proposed perhaps not allowing 8A set-asides in certain industries. There's a case called Dynalantic, I think, where someone showed that there were too many 8A contracts basically in a particular industry, disadvantaging small businesses, and you're not allowed to do certain, DoD's not allowed to do certain simulator contracts because of that decision. And so the plaintiff asked for that. They were all, and that would impact not just firms that got in with the social disadvantage narrative, but also ANCs, tribes, and NHOs as well. And then, they also, thought how do we know that anybody's actually looking at these? How do we know they're not being rubber stamped? Because you're basically describing in a paper how you've been disadvantaged, but who's really looking at that? It's not public. There's no one on the other side to argue you weren't disadvantaged in education or employment. It's not an adversarial process. And so we're, as far as I know, I haven't seen anything else. We're still kind of waiting to see if the judge in that case is going to do anything besides what he's already ruled on.
And I know just in conversations I've had with others in industry, this sort of has raised questions about the viability of the 8A program and maybe even some of the other socioeconomic programs. What's your take on that? I mean, do you see the 8A program as a whole in jeopardy as a result of this, or is this more just some nuances to policies that are going to change and everybody's going to get back to sort of the new business as usual based on the changes?
Oh, yeah, I think it's definitely at risk. I know there's a case challenging the DBE program, which is Department of Transportation's construction kind of state-based disadvantaged business enterprise program, which has a lot of the same characteristics as SDP. There are some nuances there. There's a case challenging that. I think there was just one filed at COFC challenging um, aspects that had to do with ANC tribes and NHOs. I don't know if COFC can actually decide that or not, but I think there's a blueprint out there to challenge this. And the question is, I think the program will be around, until the Supreme Court has to rule on it, and then we don't know what'll happen there. But based on maybe some of the college admission cases, you can kind of prognosticate where that might go. But
Yeah.
the question is, how will it get there? Like, if this ultimate decision, if all that SBA has to do is get the social disadvantage narratives from applicants going forward, I think they can live with that. I think there won't be an appeal. If they ban 8A set-asides in 3 different NAICS codes as they asked, I think SBA will have to decide, are we going to try to fight this? And then as you fight it, what are some of the other negative remedies that might come out of that? And then of course, if there's an election, who knows how that would impact how much you want to defend it or not. And maybe you think it is
Yeah.
unconstitutional and you won't support it. So a
Yeah.
bit, it's definitely it's not going away. This is, the program's going to be here for a little while, but these challenges are going to be here too.
Yeah. And it's interesting because there's a lot of complexity to the program beyond just small disadvantaged businesses. There's also Alaskan Native corporations and the tribally owned businesses that are wrapped up into the 8A program that operate under, in many cases, sort of different sets of rules
Right.
as well, even relative to sole source. So there's a lot of tentacles to it, for sure. Okay, so lots going on the legal front to pay attention to, and I think where we are right now is we're waiting for the court to rule on that latest set of relief requests from Ultimo. Is that your understanding as well?
Yeah, the last I heard is that nothing had, they hadn't decided. It could be any day now, and we'll
Yeah,
see. We'll see what happens.
yeah. All right, we got just a couple more topics, and then I'm going to do some Q&A when I want to make sure we wrap up on time. This has been a really great discussion and lots of good topics here. We talked in our prep about the rule of two and what the rule of two is relative to task and delivery orders. Maybe you can just share with everybody what the rule of two really stipulates and a little bit more about that.
Yeah, the rule of two that you hear about is kind of the golden rule in small business contracting, which basically says that if you think you're going to get at least 2 offers from small businesses that can perform the work at a reasonable price, then you shall set it aside. Um, what what people don't really understand is that that rule is statutory only up to $250,000. So above that amount, the FAR Council has decided that the rule will also be that if 2 or more small businesses can do it, they shall do it. But they also have the discretion to change that if they ever wanted to. Now, politically, that would never happen, but they could, for example, and they have said, well, this is not going to apply overseas outside the United States because it's too hard for small businesses to compete overseas. Or they could say, this is not going to apply to the schedule. The schedule you can, the rule of two is not going to apply, and they have done that through regulation. So that's kind of, what we're operating under over the years. There was a lot of litigation about whether the rule of two applied to orders. It's the concept is, if you're doing a contract, if small can do it, you should set it aside. But now let's say you're ordering under a contract that has large and small in it. Can you even set aside an order? Back a long time ago, when I was just starting at SBA, people would argue you could not do that because there's a law that says you have to give everyone fair opportunity to compete. And so if there's large and small in it, they both should be able to get the RFQ and respond to the order. There were also some laws that applied to DoD that said you had to, when you're doing an IDIQ contract, you had to supply the solicitation to every contractor on the contract. You couldn't set it aside for small business. So that was kind of some of the fighting that went on between agencies and SBA and litigation around that concept in the early 2000s. Eventually, there was a report called the Sarah Panel Report that talked about this and said we should do something about this, and we recommend that you give agencies the discretion, the authority to do order set-asides. And so they proposed legislative language saying you may set aside an order for small business. That eventually got into the 2010 Jobs Act, I believe. And so there's a separate section. The statutory rule of two that I talked about before, up to 250, is in 15J, and 15R of the Small Business Act is where it says you may set aside orders. And so as we proceeded, that we put that into the rules, it got into the FAR, but there's a difference of opinion on how that what that means. There's a case called Itility, I guess, from GAO, where they said, well, we may have thought the rule of two applied to orders before the Jobs Act of 2010 and Section 15R, but our reading of 15R is it says may, it doesn't say shall, and therefore it's discretionary. And so we're not gonna sustain a protest, even if smalls could do the order if an agency decides not to set the order aside. On the other hand, at COFC, there's a case called Tolliver where the judge decided that the rule of two does apply, that the FAR isn't clear enough. In the FAR Part 8 that talks about the schedule, it says it doesn't apply. In Part 16, it doesn't say it doesn't apply. It says you may do it. And so the judge, for whatever reason, decided that they were going to sustain the protest in that case against an agency that did not set aside an order.
A lot of legal interpretation in the small business contracting policies of the federal government, for sure. A couple questions have come in. We've talked about some of these. One very specific to JMU. Don't mean to put you on the spot with this one, but JMU, how could we best position itself in landing small business grants or supporting small businesses with grants? I know I was wondering about the SBIR program as a possible avenue, but I'm curious if you have any insight there that you'd be comfortable sharing.
Yeah,
the Duke's research area.
Yeah, well, I know that, and I don't know much about this, but I know what SBDCs are, the Small Business Development Centers, and they often are at universities, and there are women business centers, and there are veteran business centers, and there's I forget what they're called at they changed the name, accelerators or something at DoD, but there are ways to compete. I think you have to put in a proposal, but to get a grant to help counsel people around government contracting. And so that may be something to look into.
Fair enough. One last question here. You mentioned this sort of relationship between smalls and larges in the mentor protege program. Have you found larger companies reluctant to fully train a small in that mentor protege relationship out of fear of making them a competitor down the road?
I don't know that I've seen that. I mean, I've definitely heard, you hear the good, but you also hear the bad where a mentor is taking advantage of a small business protege or mistreating them or controlling things or doing more than they're supposed to do because there are specific rules on how the joint venture has to be set up. Um, there are requirements that the protege do a certain percent of the work, that one of their employees manage the venture and so forth. So I think large businesses, a lot of them are into this, and you can have up to 3 proteges as a large business. And so you'll see there's a list at SBA where you can see who has this relationship, and some of them have 3. They're not supposed to compete with each other. So you're supposed to have, if this protege is doing certain work at an agency or a certain type of work, your other protege shouldn't be competing with them, but you can have up to 3 as a mentor. And there's plenty of large businesses that are into this. And like I said, if you're a new large business, you know, just getting out of the small arena, no longer eligible to compete for small business set asides, becoming a mentor is a way that you can actually compete for some of the old work that you did as a mentor to a
Right.
protege. So I think it's still pretty popular and still pretty valuable. Now there are some large businesses that just won't do it for legal reasons. They don't want to, again, if you are in a joint venture, you're both jointly and severally liable for performance. So if the other partner goes bankrupt or it doesn't do a good job, that could be on you as one of the performing parties to the contract to actually make up for that. So there are some legal risks there, and some large businesses just haven't seen the strategy that it's worth it enough to
To take that
participate.
risk. Yeah.
Yeah.
Yeah. Well, we're just about at time. I've got a few concluding remarks. I did want to maybe just give one last opportunity for you. Obviously there's, as we just talked about, a lot going on in this market, but a lot of opportunity as well. What would be maybe 3 or 4 just parting recommendations or suggestions you'd have for small businesses? You certainly mentioned one, which is like making sure the mentor protege program is part of your strategy in terms of how you go to market. Are there some other things that you find worth sharing?
Yeah, I think s- to I think companies should be aware of the CMMC requirements that are just now, I think, hot off the press in terms of a proposed way to do that. You're going to have to, especially if you want to work with DoD, you're going to want to be on top of that. I mean, there's nothing you have to do right away, but you got to start preparing and start getting ready. It still has to go through the rulemaking and comment process, and it'll probably take some time, but I think that's an important thing for companies to keep in mind. I think the size and status recertification is going to be a potential issue as we go forward. There are complex rules around when you get on a contract. Are you small for the whole 5 years or 10 years under that contract, or do you have to recertify on every order? There's been some cases around that where I thought the contract was full and open and the firm should have been small at the time of their offer for the order, and they weren't. But the OHA didn't seem to think that was a problem. I think, for example, on COS before, if that ever gets awarded, that's a full and open contract. So large and small will be able to compete with each other. But you also, in order to get on the contract, they're doing a competition among small. So you could argue, well, size is relevant to get on the contract, and therefore I don't have to recertify my size every time I compete for a set aside order. So I think that'll be something to look for as we go forward. How is that interpreted by OHA and the courts?
Yeah. Great. Well, terrific, Ken. Thank you so much for your sharing your insights today, and really appreciate your expertise. Obviously, a lot going on, and then even more still with the elections coming up next year. Uh, just I wanted to encourage everybody, if you want to follow along to other events that we have planned and stay in touch with what's going on with JMU, the JMU Alumni Association, you can follow along on these social media sites. Also for the JMU Federal Dukes as well, we have a website set up, jmufederaldukes.com. We encourage you to check out there. We are going to be posting this program and the recording, as well as posting some upcoming events there. So just would really encourage you to pay attention to what we have planned ahead, and also just encourage you to get involved. Ken, thanks again for joining us today. And yeah, Go Dukes.
Thank you, Kevin. Thank you, JMU Federal Dukes.